Have you ever thought about waiting to file a tax return because you believed nothing was owing to the Canada Revenue Agency? You see, a recent federal court case shows how costly that assumption can be. Hi, my name is Amandeep Singh, and I'm a CPA practicing in the Metro Vancouver region of British Columbia, Canada. I share real tax stories like this one to help Canadians stay compliant and avoid unnecessary penalties and interest. On October 3rd, 2024, the court reviewed Ju versus Attorney General of Canada. This case involved a taxpayer who filed a large batch of late tax returns in April 2021, covering the years 2008 through 2016 and 2019. His 2008 return showed a balance owing. CRA had already issued a request to file in December 2009 and a demand to file in February 2010. But the return come in more than a decade late. The taxpayer paid the 2008 balance in May 2023, but penalties and years of interest had already been accumulated. He applied for relief asking CRA to cancel these charges on the basis of financial hardship and delays in being informed about this balance. Here's how relief works, guys. CRA can cancel penalties and interest under Section 220 of the Income Tax Act, but only for 10 years before the application. In this case, that meant relief could only apply to interest accruing after January 1st, 2012. Anything earlier than that was automatically out of scope. The taxpayer explained that he usually delayed filing if he believed no balance was owing. For 2008, he also miscalculated his tax balance. He also thought his earlier wage garnishments had cleared the account, so he considered the matter resolved. CRA reviewed this tax request twice and concluded that he had the financial capacity to cover arrears through home equity, savings, or investments. They also noted a long history of late filings across multiple years. When the matter went to court, the judge carefully reviewed CRA's reasoning. The court found that CRA had acted well within its guidelines. Financial hardship for CRA purposes only means a prolonged inability to meet even basic necessities, and this standard has not been met. CRA had also acted promptly in 2009 and 2010 to remind him of his obligations. The court concluded that CRA's decision was transparent, it was evidence-based, and it was found reasonable. The lesson is clear. Filing late, even when you believe no tax is owing, creates risks of penalties and interest. And relief is only available in very narrow situations. And once more than 10 years have passed, the window closes completely. You see, at Cloudiverse CPAs, we work with clients to prevent situations like this. We help keep filings on track, review your tax position so you are not relying on assumptions. And we also step in to support taxpayer relief applications when extraordinary circumstances apply. By staying proactive, you protect yourself from years of compounding penalties and interest. If you have fallen behind, or if you're worried about CRA interest and penalties, we can guide you through the right steps and help you stay compliant. Thanks for watching, and I'll see you in my next video. Until then, bye.